Order was passed in Puja vacation by this Honorable Court, my lord.
Give it.
She might contempt the application last
Give it whether I will pay.
yesterday. Before yesterday, your lordship, partial to lordship direction give the list. But yesterday, I came before the bench clerk of your court for listing the matter on Friday. And the bench clerk
After recording the submission of the learned counsel for the respective parties, I'm just reading my findings. I'm just reading my portion. To decide the challenge to the regularization of the engagement of 313 voluntary teachers, it is necessary to take a close look to the facts and circumstances leading to such regularization, which are detailed in the following paragraphs. The said 313 voluntary teachers were engaged between the period of 1999 to 2016. The Secretary, Department of Education of the erstwhile Darjeeling Gorkha Hill Council, DGSC in short, by the order number 1 dated such and such, dated July (30, 2010) had directed all heads of the school, primary and secondary under DGSC, that with effect from July 1, 2010, no teacher shall be appointed by the schools or its managing committee without the written consent of the Education Department of DGSC. The GTA, an autonomous self-governing body, was created by virtue of 2011 Act of 2011, and by virtue of Section 74 thereof, the Darjeeling Hill Council Act 1988 was repealed. A joint meeting to the education relating to the education at GTA area was held on November 25, 2014 at Navanno in the presence of Additional Chief Secretary, Secretary Education, Executive Sabha member, and other representative of the state and GTA. There was a specific agenda in the said meeting regarding the regularization of voluntary ad hoc teachers in secondary schools under GTA. The following resolution was adopted against the said resolution agenda regarding regularization regarding regularization, regarding regularization of the voluntary ad hoc teachers in secondary schools of GTA, Sri Roshan Giri, Executive Shobha member, suggested to constitute a recruitment board as one-time solution to resolve the vexed problem. Sri H.B. Chetri, MLA Kalimpong, also informed that 503 voluntary and 135 ad hoc teachers in aided secondary schools, additional chief secretaries, principal secretary, home and health affairs, however, expressed his apprehension that it may create a precedent which would have unacceptable consequences. Instead, he suggested a consolidated enhancement of equivalent salary for this regularization mechanism is to be devised. It is, however, requires the approval from the finance department of the state government. In the aforesaid meeting, it was also proposed that a further meeting will be held to resolve the outstanding issues relating to the school education in GTA area. But there is nothing on record to suggest that such further meeting was ever held. However, 3 years thereafter, the Secretary School Education Department, Government of West Bengal, by an order bearing number such and such dated February 6, 2017, had constituted a committee consist of Principal Secretary GTA, Secretary West Bengal Central School Service Commission, District Inspector of School AC, Darjeeling, and OSD to Minister in charge to examine the representation received from temporary teachers of the schools under GTA for the purpose of verification of the genuineness of the claim for higher scale of pay. The eligibility to get such higher scale of pay as fixed by the said order were 3 years teaching experience, knowledge of Nepali, and knowledge of relevant subjects, and the committee was directed to give its finding on the said eligibility. The Joint Secretary School Education Department, Government of West Bengal, simultaneously by a letter dated February 6, 2017, had directed the chairman of the commission to examine the said eligibility of the applicants who had applied for such higher scale of pay from the different government-aided and government-sponsored school under GTA for the purpose of verifying their claim. The chairman of the commission, under his letter dated February 13, 2017, had informed the Secretary School Education Department, Government of West Bengal, that verification of the eligibility of the said teachers as per the direction dated February 6, 2017 was conducted, and detailed list of eligible and non-eligible candidates with reasons would be submitted later. Sri Binoy Tamang, the then chairman of the Board of Administrators GTA, by a letter dated April 19, 2018, addressed to the then Minister in charge, Department of School Education, Government of West Bengal, had sent the purported final list of 271 voluntary teachers in various secondary schools under GTA, allegedly left earlier on a request to regularize such teachers in their service. The Assistant Secretary School Education Department, Government of West Bengal, by a memo dated April 24, 2018, had informed the District Inspector of Schools, AC, Kalimpong and Darjeeling, that department has received a proposal of regularization of 271 voluntary teachers. In the said memo, the eligibility criteria of such regularization were fixed. 3 years, that is 3 years teaching experience, requisite qualification, knowledge of Nepali and relevant subject, letter of engagement issued by the concerned school, and existence of sanctioned vacancy. The said District Inspector of Schools were directed to verify the said eligibility of such voluntary teachers. The Executive Director, Education Department, GTA, by memo dated June 25, 2018, had directed the headmaster, headmistress of all secondary level schools under GTA and the head teacher of all primary, upper primary and primary schools under GTA, that authority in GTA will not entertain or allow engagement of any voluntary teacher in schools under GTA. In the said memo, it was recorded that during scrutiny, it came to the notice of the authority. In many cases, the candidates who do not possess requisite qualification have been engaged whimsically in violation of the order dated July 30, 2010 of the DGSC. In the said memo, it was clarified that such engagement of voluntary teachers in contradiction of the mandates of the government of West Bengal and other appropriate authorities henceforth would be considered as personal liability of the head of the institution and its managing committee. The Board of Administrators GTA, in its executive meeting held on June 28, 2019, had approved the proposal of regularization of voluntary teachers in secondary schools under GTA as a special case, and for the said purpose had clarified that the order dated July 30, 2010 and June 25, 2018 shall not affect the said decision of the board. The District Inspector of School AC GTA, Darjeeling, by a memo bearing number such and such dated July 2, 2018, had informed the Assistant Secretary School Education Department, Government of West Bengal, that all the criteria laid down in the letter number such and such dated April 24, 2018 in respect of 271 voluntary teachers of government-aided and government-sponsored school has been physically verified. The Principal Secretary School Education Department, by the impugned communication dated March 8, 2019, had informed Sri Binoy Tanang that the then Board of Administrators, Chairman Board of Administrators, GTA, that the state government has approved the regularization of 313 voluntary teachers in secondary, high secondary schools as communicated by DIAC Darjeeling to the Directorate of Department by number 910 dated July 1, 2018. The purported regularization of 313 teachers, voluntary teachers, in reality was their fresh appointment at the government-aided and sponsored school under the GTA. The process detailed in the above subparagraphs of paragraph 8 is unknown to any selection process for the appointment of the teachers of such schools. The said Act of 1997 is an act to provide for constitution of a regional service commission in West Bengal to regulate the manner of selection of persons for appointment in the post of teacher, which came into force with effect from April 1, 1997. Admittedly, the mandate of the said Act of 97 was given total go-by in appointing the said 313 teachers in the name of regularization of their initial engagement. The rigor of the said Act of 1997 has been sought to be avoided by the respondent on the plea that the voluntary teachers were appointed in a situation when total state machinery had collapsed due to political unrest. But to keep the education system on, the said teachers were appointed, and the later on their initial engagement, later on their initial engagement were regularized. The plea is too feeble, inasmuch as the Hill region of the Commission, prior to its suspension in the year 2003, had conducted a selection process in the year 2002 for appointment of assistant teachers in different categories against sanctioned posts at recognized non-government aided secondary schools under DGSC. That apart, petitioners in their affidavit in reply to the affidavit in opposition of the respondent 13 to 132 in WPA 1089 of 2023 had filed documents to show that in the year 2015, selection process was conducted in the hill area to fill up the different vacant posts at the district judgeship and other government organizations. The initiation of such selection process certainly indicates that the situation in the hill area was not so bad for which the regular selection process could not be conducted for appointment of teachers in the schools under GTA. An argument has been advanced as on behalf of the private respondent that in view of the vesting of administrative, financial, and executive powers in the region in relation to the school education, including primary education and higher secondary education, including vocational training, physical education, government schools, upon GTA by virtue of Section 26 of the said Act of 2011 and transfer of schools in GTA area which are under the management of the state to GTA in terms of Section 60 thereof, the said Act of 1997 is not applicable in respect of the said schools. Besides, the said schools are not coming within the purview of the definition of the school as defined under Section 2N of the said Act of 1997, inasmuch as the state is not paying basic pay of the teachers, rather the state is providing non-planned budgetary support to the finance department of GTA, which in turn sanctions the fund to the education department of GTA, and the said department is paying the salaries to the teachers of the schools under GTA. The said argument is completely misconceived inasmuch as the GTA by its character is an autonomous self-governing body formed to administer the region so that the socio-economic, infrastructural, educational, cultural, and linguistic development is expedited and ethnic identity of Gorkhas established, thereby achieving all-around development of the people of the region. Nonetheless, the state, by the various provisions of the Act of 2011, retains pervasive control over GTA, though it is unnecessary to identify all those areas of control of the state. But an example of Section 25 of the said Act of 2011 can be referred to, by virtue of which the GTA is empowered to frame a regulation to prescribe a manner to conduct its business, but such regulation can be framed subject to the approval of the state. Mere distribution of salary to the teachers by the education department of GTA does not signify that the schools are not coming within the purview of the definition of school as defined under Section 2N of the said Act of 1997. And those are private schools, inasmuch as GTA, being an autonomous body, receives the fund from the state and in turn distributes it in the shape of salary to the teachers of the schools under GTA. Section 73 of the said Act of 2011 is a clear answer to the issue regarding the applicability of the said Act of 97 in the area under GTA. The said provision lays down that no provision of the said Act of 2011 can affect the application of any law, that is, any enactment, ordinance, regulation, order, bylaws, rule, scheme, notification, etc., having the force of law made before or after promulgation of the said Act of 2011, unless such law specifically provided for exclusion of the region from such application. The second Section 73 quoted. That apart, the Honorable Division Bench of this court in the case of Kiran Subba versus State of West Bengal reported in 2008 2 CHN 530 had the occasion to deal with the issue of applicability of the Act of 1997 in the respect of the schools under DGSC. The Honorable Division Bench, while interpreting Section 15 of the said Act of 1997 and the explanation appended thereto, has held the provision of West Bengal School Service Commission Act 97, the West Bengal Board of Secondary Education Act 1963, and all the rules are obviously applicable, save and except the explanation provided in the respective acts thereof. In view of the said decision of the Honorable Division Bench, I am unable to follow the decision of the learned single judge of this court in the case of Balkrishna Limbu, cited on behalf of the respondents. The Honorable Division Bench of the decision of the Honorable Supreme Court in the case of Pradeep Biswas and Board of Control of Cricket of India, cited on the respondents in the facts and circumstances of the case, are therefore completely misplaced. In view of the discussion made above, all arguments of Mr. Majumdar on the issue of applicability of the said Act of 1997 and the applicability of the notification dated October 22, 1997 and February 5, 2004, both issued by the School Education Department, Government of West Bengal, to include District Darjeeling within the northern region of the West Bengal School Service Commission and in hill region of the Commission, are rejected, being fallacious. The state, its affidavit in opposition, has disclosed its stand. The state in this said affidavit has specifically stated that though the letter of the then chairman of the Board of Administrators GTA dated April 19, 2018 to regularize 271 voluntary teachers was under the consideration of the School Education Department, and in continuance thereof, the Commissioner of School Education was directed to work out the estimated financial cost of the proposed regularization of 313 voluntary teachers in school or higher secondary schools under GTA, and to furnish a copy of such estimate to the School Education Department along with the formal proposal, but no estimate has yet been received in compliance with the said direction. The District Inspector of School AC Darjeeling was aware that the communication of the School Education Department dated March 8, 2019 was in principle approval, not the final. The School Education Department thus awaiting the response of the financial implication of regularization of 313 voluntary teachers, after which the said report of final after which the said report of the financial implication would be placed before the Finance Department, followed by the decision of the Cabinet for final approval, as it was done in previous instances of regularization of 439 voluntary teachers. It is argued that on behalf of the state, that state came to know about the appointments of 313 voluntary teachers from an affidavit filed by GTA, which was subsequently withdrawn. The School Education Department had constituted a committee consist of Commissioner of School Education, Joint Secretary, Secondary Education Branch, School Education Department, Deputy Director, Grant in Aid Section A, Grant in Aid Section, Education Directorate, and representative of District Magistrate Darjeeling to cause an inquiry as to how appointment approval of 313 candidates as mentioned by the ETA in its affidavit have allegedly been made without waiting for the final approval of the state government, though through Finance Department and Cabinet, as it was done in the case of appointment of 439 voluntary teachers in the year 2017. The Commissioner of School Education West Bengal, under his letter bearing number such and such dated October 9, 2023, had submitted the inquiry report of the said committee before the Principal Secretary, Government of West Bengal School Education Department. A copy of the said report was filed before this court. The analysis and the conclusion of the said report is quoted below, which itself would demonstrate the illegality committed in appointing the 313 teachers in the name of regularization. The analysis and the recommendation of the said report are reproduced below for ready reference. Then the analysis and recommendation, I'll be reading the recommendation part only. From the findings as stated above, it is revealed that Sri Pran Gobindo Sarkar, ex-District Inspector of School AC, Darjeeling, has committed an offence by approving 313 voluntary teachers, knowing fully aware that act was not as per approved procedure without any valid ground of justification. Hence, departmental proceeding may be drawn up against him following the procedure, as he is a retired person now. The Deputy Secretary, School Education Department, on the basis of the said inquiry report and recommendation thereto, had lodged a complaint with the Bidhannagar North Police Station against the District Inspector School AC Darjeeling and others, being Bidhannagar North PS case number 75 of 2014 and 2020-2024 under section 186 506 IPC, read with 7 small a 7 capital A of the Prevention of Corruption Act 1988. The said criminal case though has ended in final report, but the report of the inquiry committee and the initiation of the said criminal case certainly signify that a regularization of engagement of 313 volunteer teachers was done in violation of relevant laws. In the aforesaid backdrop, I am unable to accept the argument of Mr. Kaur. The government, after extending all benefits of a regular teacher to the said 313 voluntary teachers, now cannot turn back and say the approval of regularization of initial engagement of 313 voluntary teachers was an in-principle approval pending final approval. That being the position, the decision of cited by Mr. Kaur in the case of Ishwar Singh, Rajnikant, Raman, Bipin Kumar have no manner of application in the present case. The state never took a final decision to regularize the engagement of 313 voluntary teachers. Therefore, there is no question that the state is attacking its own decision in the present petition, or dispute between the government departments has been sought to be settled here. Consequently, the decision of Raghav Gopalacharya, the chief conservator of forest government of AP, are misplaced in the facts and circumstances of the present case. The regularization of 313 volunteer teachers is not a final decision of the state, far less a policy decision. Therefore, the decision cited on behalf of the respondents on the scope of judicial review to the policy decision of the state deserves no consideration. The petitioners are educated youth of Hill region. Filling up the vacant post of the government-aided sponsored school under GTA without following any known selection process is a fraud practice upon the petitioners, as though they were eligible and deserving candidates, but they could not offer themselves for the said vacant post, which certainly has affected their rights guaranteed under Article 14 and 16 of the Constitution. As such, objection to the locus standi of the petitioners to maintain the challenges, particularly to throw challenge to the decision of appointment of 313 voluntary teachers in the name of regularization of their initial engagement in the schools under GTA is overruled, and in view thereof, the decision of the Honorable Supreme Court in Roshan Kumar and Ayub Khan, Pathan, Anuj Garg, cited on behalf of the state, have no manner of application in the present case. The voluntary teachers admittedly were engaged temporarily without following any selection process. Regularization of such engagement offends the constitutional scheme. The following observation of the Honorable Supreme Court in the case of Uma Devi, being relevant to the context, are quoted below. It would not be appropriate to gestation the constitutional scheme of appointment and to take the view that a person who has temporarily or casually got employed should be directed to be continued permanently. By doing so, it will be creating another mode of public employment which is not permissible. The Honorable Supreme Court, in the case of Kishan Gopal Vyas, Supra, has held that any order or absorption and regularization of a person not appointed in accordance with rules resulting denial of equal opportunity in the matter of employment to other candidates for the public offices. Such a course must obviously be eschewed. Paragraph 7 of the said judgment is quoted below for ready reference. 7 quoted. The appointment of teachers in government aided and sponsored school is regulated by the provisions of the said Act of 97 and rules and regulations framed thereunder. The voluntary teachers have been appointed in the name of regularization without following any rules and regulations. Honorable Supreme Court, in the case of Sulekh Chandra Pradhan Supra, has held that appointments made in contravention of the statutory provision are void ab initio. The Honorable Supreme Court, in the case of Dr. Arundhati Ajit Pararkar, held that eligibility and continuous working for however long period should not be permitted to overreach the law. Requirement of rules of selection, through commission, cannot be substituted by human consideration. The Honorable Supreme Court, in the case of Y. Token Singh, has held the appointments in violation of the constitutional and legal scheme are not binding on the state. The Honorable Supreme Court, in the Dharanidhar, Misro and other versus state, reported in 2024 10 SCC, has observed, in a case where a demand for justice is so compelling, a constitutional court would exercise its jurisdiction with a view to promote justice and not to defeat it. The Honorable Supreme Court, in the case of Vidya Devi versus State of Himachal Pradesh, reported in 2020 Volume 2 SCC 569, has held, delay and laches cannot be raised in a case of a continuing cause of action or where the facts shock the judicial conscience of the court. Moreover, no period of limitation for courts to exercise constitutional jurisdiction to do substantial justice. In the present case, the action of the year 2019 has been challenged in the writ petition filed in the year 2023. Process of appointment of 313 voluntary teachers in the name of regularization admittedly was not done by any advertisement or public announcement. Therefore, it cannot be presumed the petitioners were aware of such regularization. That being the position, this court holds that the challenge is well within the time, as such decisions cited on behalf of the respondent on the issue of limitation need not be discussed. The National Council for Teachers Education, by its notice dated September 3, 2001, had framed the National Council for Teacher Education determination of minimum qualification for recruitment of teachers in school regulation 2001. In supersession of the said regulation, the National Council for Teacher Education Regulation 2014 was notified on November 12, 2014. Graduates in Bachelor of Education, since from the date of first notification was the mandatory training qualification of the teachers for secondary and higher secondary schools. Most of the voluntary teachers did not have the requisite training qualification at the time of their initial engagement as voluntary teachers. The said shortcoming, even if it's ignored, but at the time of their appointment in the name of regularization in the year 2019, they must possess the said qualification. It appears from the list of 313 teachers annexed with the supplementary affidavit of GTA filed on April 29, 2025, that they did not have the training qualification. All of them acquired such qualification after their appointment in the name of regularization. The shortfall in the said mandatory shortfall of the said mandatory qualification cannot be made good by acquiring the same subsequently. The Honorable Supreme Court in the case of Anand Kumar Jadhav has held proper qualification is mandatory, cannot be waived. The decision of the Honorable Supreme Court in the case of Chandramohan Negi in the matter of, and in the case of Malathi Das, and in the case of Ram Sarup are no help of GTA for the GTA, as those decisions are clearly distinguishable in facts. The decision of the Honorable Supreme Court in the case of M.S. Mudhal, as cited on behalf of GTA, is no pointer to the issue under consideration. The decision of the Honorable Supreme Court in the case of Srinivas Bhatt and the decision of the Honorable Division Bench of this court in Alil Kumar Zalo are not applicable in the facts and circumstances of the present case, and the decision of the Honorable Supreme Court in the case of Mahinder Singh Gilgis has no manner of application in the present case. At the conclusion of the argument, Mr. Vishwarup Bhattacharya advocate has filed the copy of the judgment dated December 3, 2020, and passed by the Honorable Division Bench of this court in MAT 873-23, West Bengal Board of Primary Education and other versus Priyanka Noskar and other analogous appeals. I do not find any relevance of the said judgment to the present conclusion. Summing up the debate discussion made above, this court holds the appointment of 313 voluntary teachers in the name of regularization, whose particulars have been disclosed in the supplementary affidavit filed by GTA on April 29, 2023, is illegal. Accordingly, the impugned letter bearing number such and such, March 8, 2019, whereby and whereunder the engagement of 313 volunteers were regularized by the Principal Secretary, School Education Department, Government of West Bengal, set aside and quashed. The connected applications being CAN 6, CAN 7, filed by respondent number 7 and 8 are dismissed without any order as to writ petitions be included in the monthly combined list of January 2026 to answer the other pending issues. Now, what the next course? I have washed my hand. এটা কালেকশন হবে কিছু কিছু. Now the case is over. I don't know when this will be before the other court. What will be the prayer of the petitioners?
This is a circuit bench matter. শোনো না, একটা ছবি তুলে দাও প্লিজ।
সব কটা ব্লার হয়েছে, আর তোমার এই ফোনটাও না এতটা পুরনো হয়ে গেছে।
पॉलिटिकल पार्टीज पैसा देके इन पोलिंग